Hello and welcome to the Rogers Brief for May 18th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. I hope everybody's having a good Victoria Day weekend, the May long weekend. Got some trail running in here myself today, looking to get ready for next week's Cabot Trail Relay. This, for those not familiar, happens every year now for I don't know how many years. It's got to be 30, maybe more. 17-stage team race around the Cabot Trail. Everybody runs sort of 15, 16, 17 kilometer segments and they do the whole thing. So this is I think my fourth time running it. I've run I think leg 13, leg 9 and leg 10. Now I'm doing 17, which is the final leg. Runs into Bedeck on next Sunday. So anyway, if anybody's around for the Cabot Trail Relay, say hello. I'll be glad to say hello too. And then tomorrow going to Lance for some fast pitch provincial evaluation and have pitchers and catchers for in the teen years, the U17, U15s, U13s. So checking out some pitchers from around the province. Seeing what we have for talent and working with some of those to make sure that we have strong provincial representation when Nova Scotia goes away to national tournaments. So good long weekend, good way to spend a long weekend, I think. So some interesting stories this week, and I want to get to them right away. Of course, what I'm going to be talking about, we've some things in the news throughout Canada. These protests in university campuses across the country, more so in the States, but up in Canada too. Now McGill University applied for an injunction to remove the protesters. I'll talk about that a little bit. Some news, sort of Nova Scotia news, Canada-wide news in a sense, but the Chignecto Isthmus that's been in the news this week. And I'll talk about that. There's a lawsuit involved between the province of Nova Scotia and the federal government over who should be responsible for fixing the Chignecto, or fortifying, I guess, the Chignecto Isthmus. Nova Scotia focused, a couple of cases that are in the news, so I want to talk about. One is Colin Tweedy, found guilty in Cape Breton, dangerous driving causing death in the death of a 10-year-old girl from 2019. This was the second trial. This is a retrial, found guilty by judge alone. And then the situation at Halifax, at the Halifax Shopping Centre, where the 16-year-old Syrian refugee killed purportedly, allegedly by other youth. 4 of them have been charged with second-degree murder, and so that was before the court's trial dates have been scheduled, so I want to talk about that. But before we get to any of that, I want to go down south for a moment and talk about some U.S. legal news. The big news out of the United States legal news is not the former president, but the number 1 golfer in the world, Scottie Scheffler, arrested yesterday morning in Louisville, Kentucky. So one of the 4 major tournaments, PGA Championship, is going on in Louisville. Scottie Scheffler was arriving at the golf club to do some, get a workout in, do some warm-ups before his round. And there was a traffic accident. Actually, somebody was killed. He didn't realize this at the time. The police were out redirecting traffic around. He apparently went to go around the traffic, as the players have been told they should do. If there's any traffic issues, just put your 4-ways on, go around. We'll figure it out. Well, he was arrested, charged, and the Louisville police are saying that the number 1 golfer in the world, Scottie Scheffler, dragged or hit a police officer. So he's charged with assaulting a police officer, disobeying instructions, dangerous driving. Now, the reports coming out early on, Scottie Scheffler, he then went out and shot a 66, so 6 under par. Good round, really good round, even for his level. Although today, actually, when I checked, that was his second round. today he's +3 through 5 holes, so not having a good second day. A lot of pressure, although you would think golf might be a way to escape that kind of the pressure and just focus on the game. Anyway, so he's been charged, and we'll see where it goes. The report from the officer says that he had abrasions and bruising on his wrist, and that his police pants were damaged beyond repair. I'm not sure exactly what that might mean, but that's the report from the police. So we'll see. Scotty Scheffler, and because players, this is an interesting case now, because normally as the lawyer you'd be like, well, don't say anything about it, except you're the player and you're at a golf tournament and they are obligated to sit in front of, by their contracts. Same with, hockey players, any sport. Part of their collective bargaining agreement is after the event you have to go and talk to the media. And so there was Scotty Scheffler talking about this incident, trying not to say too much. I think he was prepped fairly well beforehand. He was confused by the instructions and that sort of thing. And he seems to think that it's going to go away quickly. He's got court on Tuesday. Anyway, see how he does in the tournament. Dropping 3 shots in the first 5 holes on round 3 is not a good sign for him to actually win the tournament. That would be something. Other big U.S. Legal case, of course, is Donald Trump in court in Manhattan. This week, some interesting stuff. So Michael Cohen, Trump's former lawyer, so there goes solicitor-client privilege in all its facets. Michael Cohen, Trump's former lawyer, testifying against the former president this week, and saying, so the case, this is the case in New York where his lawyer, Michael Cohen, paid Stormy Daniels to not say anything about Donald Trump. Okay, so $130,000 paid by Michael Cohen. Trump then paid Michael Cohen the $130,000 as legal fees, and because it was actually supposedly for some other purpose, a transfer of funds through to Stormy Daniels, that is campaign financing of violation, and therefore, falsifying business records for a campaign purpose. Anyway, it's a long string. There's several connection points that need to be made by the prosecution in order to convict the former president, but a lot of it rests on Mr. Cohen, and he has 1 or 2 conversations that he testified where he discussed, the arrangement and how the record keeping was going to go in order to sort of conceal the hush money element of this situation from, with the former president. Now, as the only witness that makes the direct connection between the former president and the improper business records, before, all right, well, Stormy Daniels got paid, Michael Cohen did it. All of these things were sort of, the president was insulated from those kind of things. And then all of a sudden there's this connection, not all of a sudden, but the connection point is between Cohen, his former lawyer, and the president. Well, anyway, like I say, they seem to have dispensed with the whole issue of solicitor-client privilege. One of the exceptions to that is if it's in support of a criminal enterprise. You can breach, or you can pierce the veil, I guess, in a sense, of solicitor-client privilege if there's a criminal enterprise. Not always clear where that line might be. But anyway, so Cohen was quite calm on the stand, but Trump's lawyers, I see, played some podcast audio that Cohen, so he was trying to portray himself on the stand in front of the jury as very calm, cool, collected, a lawyer trying to, match wits with the Trump defense lawyer, which would, of course, bolster his credibility. And so Trump's lawyer wisely used some footage from Cohen's own podcast where he was, a little more animated, sounding like he wanted to get the president. So, all right. So that tends to show that Cohen is out to get the president and would maybe lie in order to do so, in order to accomplish that. Not sure how that's going to go. So been to many law conferences where lawyers from the United States were brought up. I was down in New York maybe 15 years ago, so to the American Bar Association's annual conference. I mean, the lawyers down there, I mean, they're just operating at another level in a sense. I mean, the stakes are so high. And so often when one of these American lawyers would come up, you'd be like, wow, this guy is the guy or girl would be like, well, they know, I mean, because they're operating at the major league level, they must be great. Well, Trump's defense lawyer had, I think the New York Times reported, I think there was 14 or 15 sustained objections, really broke up the flow of the cross-examination of Michael Cohen. Not a great sign. Sometimes when you have sustained objections, there's a purpose from the defense lawyer's perspective. Maybe you want to ask a question in a certain way, knowing it's going to draw an objection, but you want to, get a reaction from the witness or see how far you can push the line with the judge. But, when you're getting over 10 of those, that's usually a sign that you're not as well prepared or good on your feet as you should be in that situation. They seem to be employing a strategy in this case of, okay, Michael Cohen, here's, 10 other situations where we know you've lied, so you must have lied about this one. All right, that's not a bad strategy. It's not a great strategy. It's not the first one you would go with. Normally, it's like you want to focus on the connection point, the point of, where Cohen says he told the president that this was the records and this is how it's going to go. But mostly they've focused on, all right, he's lied so many other times, he must be lying about this. There is one sort of piece of evidence. There was a phone call that he said he made to the president, but the records show that it was on the president's bodyguard's phone. All right, maybe not unusual. Here, boss, here's the phone, here's your lawyer. We're using this phone. But defense is alleging that was a phone call to the bodyguard because Michael Cohen was being harassed and wanted to talk about some other issue with the bodyguard. So some dispute about that phone call. Anyway, so we'll see where it goes. So the Monday, not Victoria Day in the United States, of course, they're going to see whether the defense is going to be calling any evidence. They might call this bodyguard. It wouldn't be, I don't think President Trump's going to testify. Don't want to put the president in a position where a judge who seems to be a little antagonistic with him has an opportunity to comment on his credibility. So I don't think that's going to happen, but maybe put the bodyguard on to talk about this other phone call. Otherwise, I don't expect much defense evidence. They're looking at closing arguments on Tuesday. I'm sure there'll be lots of scrutiny over all that. So anyway, that's what's going on in the States. Probably talked about that more than I intended to. Okay, let's move up to Canada. I want to move on to the McGill protest. So some students had brought an application at McGill. This is, of course, the Middle East situation, drawing some protests, some counter-protests, all these things. Many U.S. campuses in Canada, it's been seemingly McGill, U of T, Vancouver, maybe a few other smaller protests set up. But McGill was the only one. So some students had applied for an injunction ending the protest. Court rejected that. The university itself last week applied for an injunction, and Justice Marc St. Pierre of the Quebec Superior Court says no, that there have been no serious incidents, no violent incidents, and in fact, even there was a confrontation between the protesters and the counter-protesters, and even that was peaceful. So, no, freedom of speech, freedom of association trumps that kind of application. All right, so McGill has property rights and they want to use their space, but there's countervailing rights here, and if there's no violence or serious threat of violence, then court's going to come down on the side of not granting that injunction. Not smart for McGill to make that application, in my opinion. If you're making an application for an injunction, you better have some serious evidence, and didn't sound like they had evidence of actual harm being done, physical harm. Maybe people feel, if you have people feeling threatened or feel, subjective feeling of discomfort or something around protests, or they don't like the loud yelling or something, well, that's one thing, but you have to have something a little more credible than McGill brought to the table here. So that's probably a good thing. I mean, not everybody likes the subject matter of what's being protested or the point of view the students are trying to make, but you have to respect the right to make that point and put themselves out there. All right, the question of whether this is a national story or a Nova Scotia story is part of the dispute. And this is related to the Chignecto Isthmus. And this is the space of land between, it's in Nova Scotia and New Brunswick, around that border, very low lying, and there's a real risk, especially with increasing storm activity, that this could, we could lose some transportation links, roadways, railways, crucially, in my opinion, and between, the rest of the country and Nova Scotia and Newfoundland and Labrador, of course, too, because so much activity takes place from Newfoundland and comes across at North Sydney, Port aux Basques to North Sydney ferry, and then through to the rest of the country through Nova Scotia and New Brunswick. Okay, so that's the question. And now Nova Scotia this week put out a letter and some comments from the Premier and others calling out the federal government, saying that they should be paying for however much money it's going to take to fortify the Chignecto Isthmus to make sure that storm activity doesn't wipe out the transportation links. You can imagine if that was, all of a sudden, if it happens, if it floods, how much more difficult it's going to be to repair it than it will be to fix it in advance, bolster it, fortify either side of it to make sure that it doesn't flood. Okay, so the province has apparently a $650 million, I think was the number for what it's going to cost. Province puts out a press release this week because the federal government decided they were going to spend all this money on a bridge in Quebec, saying that it's a vital link for the country. Aha, well, so is this. So is the Chignecto Isthmus. Now, the question is, is it the federal government's responsibility? Is it the province of Nova Scotia's responsibility, or some blend? I looked at the Constitution. The Constitution talks about provincial authority in Section 92, and it covers what they call, quote unquote, local works. Now that means local works and undertakings. And then there's three categories of things that are not included. The first is transportation links, including railways, not roads, but railways. So, there's a railway going through there that connects everything east of the Isthmus, the Nova Scotia-New Brunswick border, to the rest of Canada. But then it says, or projects that the Parliament of Canada, the federal government, has declared to be for the general advantage of Canada or two or more provinces. So, in this case, the Isthmus, of course, is beneficial to Newfoundland and Labrador, Nova Scotia, New Brunswick. Well, it's to the benefit of many provinces because there's goods flowing back and forth. For the general advantage of Canada or two or more projects, the problem is that the Parliament of Canada has not declared it to be that the Isthmus itself or the proposed project to bolster the sides of it, those are both, I think, the province of Nova Scotia can make a strong argument that those would qualify and should be declared by the federal parliament to be for the benefit and advantage, general advantage of Canada or two or more provinces. So anyway, we'll see. The Premier was talking about Nova Scotia Liberal MPs not stepping up and forcing the federal government to do this, to pay for this and take over this project. I think where we'll end up is the province paying some portion, certainly less than half, maybe less than a quarter, but probably putting some money in, although constitutionally it seems like they certainly have the Constitution on their side. Now, there's law and there's practicalities, and we'll see if there's some negotiation going on there. All right, let's get into Nova Scotia. Two Nova Scotia cases I wanted to talk about just fairly briefly. One is this case out of Sydney. Colin Tweedy, found guilty. This was a retrial. He was charged in the death of Talia Forrest, 10-year-old girl biking along the road, and he struck her with his vehicle, alleged to have been consuming alcohol at the time. Seemed clear so he was found not guilty at trial. Crown appealed, Court of Appeal overturned the acquittal, sent it back for retrial, and this was the retrial. Retried in front of a judge alone. Interesting decision not to go in front of a jury. Probably the right decision, although he was convicted again, so every question, you wonder what a jury might have done, but it seemed like sort of a technical legal argument to certainly a jury wouldn't be sympathetic to anybody charged with killing a 10-year-old girl, so probably right to go with the judge alone. And it seemed like, just reading the decision and the Court of Appeal treatment of it, that the likely outcome would be if the Crown just did a better job the second time around, that he was going to be convicted, and that's what he was. Tony Mosvik, the lawyer for Colin Tweedy, a good lawyer in Sydney. Everybody dresses casually now. Tony Mosvik, I think, is the only lawyer I know that's taken that in the legal sense. He's doesn't wear a tie to court sometimes. I think he's the only lawyer I know that doesn't. But experienced, good lawyer. He said they're considering an appeal. I think that's probably unlikely at this stage, but I haven't studied the decision like Tony has. But Justice Kevin Cody, that rendered the decision, well-respected justice, so I think that's probably the end of that one. We'll see what, he has yet to be sentenced, so we'll watch for that in the next probably month or so. Other case out of Nova Scotia is youth matter in the Halifax shopping centre. The stabbing death of Ahmad Al Marrach, 16-year-old Syrian refugee student. Well, he'd been here in Nova Scotia for 8 years. Stabbed allegedly by, 4 other youths. 2 16-year-olds and 2 14-year-olds have been charged. The 2 16-year-olds were, you might recall, originally charged. Then they were arrested, released, and then a few days later arrested again. But the 14-year-olds were the first ones charged. Boyfriend, girlfriend, I understand. The boyfriend, who's apparently posted on Instagram with some somewhat incriminating claims or suggestions from what he posted. Now, all 4 of the youth are currently locked up, pending trial. Trial date has been set. Actually, because it's a youth matter, these trial dates get accelerated and prioritized, that is. So they have trial dates, a joint trial. Could have been tried separately, but a joint trial makes sense in this case where 4 are charged with 1 incident. Well, I'll come back to that. The trial date is September, I think, 23rd start, and probably go for a couple of weeks. The 14-year-old girl is the only one of the 4 seeking a bail hearing. Her defense lawyer is Anna Mancini, who you may recall from her work in the Mass Casualty Commission. Did good work at that point. Seeking bail, so there must be 2 things. One is she must have somewhere to go, a good surety and a good plan. The second thing she must have, though, is a less strong case against her individually among these 4. I was curious. I'll be curious to find out what happens with the 2 16-year-olds who were, arrested originally, had left on a bus apparently, and then they were let go, arrested again. As video evidence of anything or what's taken place? Has somebody given a statement that implicates them? Maybe the guy, the 14-year-old may have said they were involved. Who knows? But that's the curious element of all of this. We'll be watching for that, of course, and chatting more about that, I think, Sunday night with Paul Palango and Jordan Bonaparte tomorrow night at 9:15 on YouTube. All right, so those are the Nova Scotia case. The last thing I wanted to talk about is an old colleague, a former colleague. I guess he's older than me, but not that old, which is Ron MacDonald. Ron MacDonald is retiring as the head of the British Columbia version of SiRT, the Serious Incident Response Team. This is the police oversight board in Nova Scotia that actually, when they started in Nova Scotia, Ron MacDonald was a prosecutor in Anitgonish, provincial prosecutor, and he took on the role, the first director of SiRT in Nova Scotia. Then he moved on to BC, where he operated the same kind of thing there. Different system in BC, though, as he mentioned in his retirement remarks. He says that in BC, less than half of the referrals that the SiRT equivalent there makes lead to charges. So the police oversight board says, well, this officer should be charged with assault, with whatever, right? And that he's made 39 referrals for charges, and only 18 have led to charges, so 46%, and 0 of those some of them have pled guilty. He didn't say how many, but of the ones where the officer has pled not guilty, none of those have led to convictions. So it points to a problem in the prosecution of those, the prosecution service and the prosecution of those charges. And so what Ron has recommended is a really good recommendation, is to have independent prosecutors, because provincial prosecutors are working with the police all the time. Even if they're not working with the individual officer, they're working with police. And so they're going to have, you develop relationships of trust and professional relationships there. And it's difficult to then turn that around and see police in a different light sometimes. And so I think the recommendation that he made to have independent prosecutors to deal with those, if there's enough of them, or just, make sure that you have somebody that's available to do independent prosecutions or consider them. Now the difference, I was like, well, that's, if your referral and only half of them are leading to charges, that doesn't seem great. Different in Nova Scotia. Here in Nova Scotia, the director actually lays the charge. It's not a matter of referring it to the prosecution for consideration. I see Paul sent around a story. There's a situation in Edmonton too, in Alberta, where the SiRT equivalent in Alberta recommended a charge. It wasn't laid, and so it's a different system there. I think the Nova Scotia one, if you have the ability for the SiRT equivalent, the police oversight, to lay the charge and then have independent prosecutors, then I think you have a system that's going to have trust, that people are going to have confidence will do the job when it's needed. Something that connected to this, and I might talk to Paul about this tomorrow night, this Quebec court decision from last week. It was a police disciplinary hearing that got appealed to the court. And the issue was whether police are making notes at all times when they're investigating a file. They then take those notes, turn them into a report, and that all gets disclosed to the defense. Well, the Quebec court said those police notes were not disclosable, that they were the notes of the officer, and you shouldn't. It goes to the principle against incriminating yourself. So I thought it was interesting because that Peel, there was a decision I talked about, I think, on the Sunday night show a week or two ago. The Peel police were trying to keep their police officers' names anonymous, and the decision in the Ontario court said, well, listen, police, you guys when you take on this job, you're going to be a public figure in a sense, and you give up a lot of your rights to privacy. The Quebec court said that doesn't extend to their notes, which they make, which they can keep private. It may show their how they investigated and may incriminate them in some way, and so they get to keep those private. So interesting. This was led by the police union in Quebec, and I would suspect that they will extend that argument around the country for any of these SiRT equivalents. So there's some adjustment. There's a period of an adjustment, or there's going to have to be a period of adjustment for these SiRT-like organizations around the country, watching some of these decisions come down and limiting in some ways their effectiveness. So I'll be watching for more of that. I'm sure Paul will have some thoughts on that again tomorrow night. So that's everything I wanted to talk about this week, and glad that you were here to watch along. Hopefully join us tomorrow night on the Sunday night show at 9:15, and then if you're running the Cabot Trail Relay next week, hopefully I'll see you there. And last thing is go Oilers. Oilers playing Vancouver tonight in a crucial Game 6, so we'll be watching for that and staying up late to watch a little bit of it anyway. So until next time, thank you everybody for watching. Thanks for listening, and we'll see you next time.